Broken Antler Ranch is a 40-acre, three-generation cattle property, first staked by the current owner's grandfather in 1961. The ranch has been continuously used as a working operation through the father's lifetime and into the present, with a house and outbuildings that remain plainly agricultural. 5 years before the dispute, the surrounding landscape changed when a developer purchased former BLM acreage bordering the ranch and constructed Sage Valley Estates, a subdivision of 142 homes with mandatory dues of $340 per month and codified community standards. That residential build-out placed a modern HOA community directly beside an older agricultural parcel, creating a clear geographic juxtaposition between subdivision aesthetics and long-standing ranch use. Because the ranch predates Sage Valley, by roughly 6 decades it is not a member of the HOA, and is not bound by the association's covenants, conditions, or restrictions. Geographically, the ranch now appears as an island of agricultural use amid newer residential construction. Legally, it remains separate. That distinction frames the case. The HOA's governance and enforcement powers run to its member parcels, while the ranch continues agricultural operations under applicable county and state law, independent of HOA rules. The result is a bright boundary. One side governed by privately adopted standards, the other operating as a legacy working ranch. The principal parties are straightforward. The owner and narrator, Garrett Murdoch, is 52, a third-generation cattle rancher who divides his time between weekday industrial welding work in Colorado Springs and weekend and summer operations on the ranch. He is unmarried and has no children. The property functions as his retirement plan and core identity. His father recently died after an 18-month battle with pancreatic cancer, having long stewarded the land. The property passed to Garrett, with probate timing later becoming relevant to filings that appear in the record. On the association side, the key figure is Delphine Arquette, 58, the HOA president, a former real estate agent described as focused on curb appeal, property values, and maintaining community standards. Immediate tension arises from contradictory expectations at the boundary between agricultural and suburban property. According to the background, Delphine has asserted, without substantiation, that nearby home values are depressed by $40,000 per house due to adjacency to the working ranch, and she has characterized the ranch's traditional appearance and livestock as inconsistent with subdivision aesthetics or a hazard. From the owner's standpoint, the ranch's senior presence and non-membership status mean HOA rules do not apply. This conflict of assumptions, subdivision governance versus independent agricultural use, sets the stage for later actions aimed at creating leverage. 2 structural themes complete the setup. First is the governance boundary, a mandatory association regulating 142 lots, contrasted with an older agricultural parcel outside HOA jurisdiction. Second is timing. Illness, death, and probate created a vulnerable period that, according to the background, was exploited to attempt rapid change and control. The sections that follow proceed chronologically from petitioning and code pressure to a misused easement claim and coordinated inspection timing, then to the discovery of a recorded quitclaim deed and the owner's documentation protocol, financial analysis inside the HOA, and the eventual public and legal outcomes. Shortly before the father's passing, the Homeowners Association began advancing claims aimed at drawing the ranch into its jurisdiction. During those final weeks, HOA President Delphine Arquette circulated a petition stating that Broken Antler Ranch was abandoned, its buildings violated community standards, and its livestock created health hazards. According to later accounts from residents, many signatories misunderstood what they were endorsing. Several believed the petition concerned snow removal, street maintenance, or pothole repairs. Nevertheless, 89 signatures were collected, providing an appearance of broad community support. The petition was submitted to county officials as justification for demanding that the ranch owner remediate the property or sell it immediately. The first direct enforcement effort followed within days of the father's funeral. A county code enforcement notice was stapled to the ranch gate, marking an abrupt escalation from rumor to administrative action. Soon afterward, a certified letter arrived from the HOA's president citing an alleged 1987 easement that, she claimed, granted Sage Valley Estates shared access to the ranch's creek corridor for landscaping improvements and riparian zone maintenance. The letter imposed a 14-day compliance deadline and quoted Colorado Revised Statute 3833-31166 as authority, a citation that appeared formally plausible yet, as later shown, was contextually misplaced. Determined to verify the claim, the owner visited the county clerk's office in Canyon City, paid document copy fees, and spent several hours reviewing microfiche archives. The original easement proved to have no relation to community landscaping. It had been recorded for a private utility company's natural gas line, limited to subsurface access, and had expired automatically in 2002 without renewal. The discovery invalidated the HOA's shared access assertion. The owner's immediate takeaway became a procedural lesson. Government recorders simply log what is submitted. They do not authenticate or interpret its meaning. So factual verification rests on the affected party's diligence. After refuting the easement narrative, the owner filed a Freedom of Information Act request, seeking all correspondence between county officials and Sage Valley Estates. The released emails established that Delphine Arquette had maintained an 8-month dialogue with a county planner named Brock. Those exchanges revealed that code complaints and inspection schedules were being coordinated to coincide, creating a sequence of pressure events. One highlighted statement read, "Once we establish access, the rest is easy. He'll sell or we'll foreclose." Although the ranch fell completely outside HOA boundaries, the strategy seemed aimed at manufacturing the appearance of oversight and eventual leverage through bureaucratic repetition. Taken together, the petition, the manufactured abandonment narrative, and the misapplied easement demonstrated a pattern. Stack small procedural acts until they resembled authority. The correspondence confirmed that such actions were not spontaneous, but planned. By using petitions, selective citations, and synchronized inspections, the HOA president and her collaborator attempted to convert neighborhood annoyance into formal county action. The owner's realization that these moves were deliberate, not mistaken, transformed a local nuisance into a recognized campaign of property control pressure. It also marked the transition from reactive frustration to methodical evidence gathering, a shift that would define the next phase of the case. While continuing to monitor county filings after the earlier easement dispute, the ranch owner made the discovery that would redefine the entire case. Among the morning updates on the county recorder's website appeared a new document, a quitclaim deed transferring Broken Antler Ranch from the deceased father to the Sage Valley Estates Homeowners Association, designated Trustee for Community Benefit, for a recorded consideration of $1. The filing listed Delphine Arquette as HOA authorized agent. The date revealed that the instrument had been executed weeks after the father's death and months before probate proceedings could legally conclude. For the owner, the timing immediately signaled deliberate exploitation of an administrative gap. The recorded document appeared facially legitimate, but carried structural red flags. A quitclaim deed does not verify the grantor's ownership. It merely transfers whatever interest the signer may possess. Because the clerk's office serves as a repository, not a verification authority, Staff simply recorded the submission without checking identity or confirming that the supposed signer was deceased. That mechanical process, while standard in public recording systems, made the instrument instantly effective in the index, even if the signature was fraudulent. The entry's presence on the record was enough to trigger other administrative responses, including an apparent change in tax payment status and subsequent notices. Seeking immediate verification, the owner drove to the UPS store listed as the notary location. There, a clerk explained that security footage operated on a 30-day overwrite cycle, long expired by the time the owner arrived. With no video record remaining, he turned to direct signature comparison, collecting 23 genuine examples from wills, power of attorney forms, and bank documents. He placed them side by side against the quitclaim signature. The contrast was unmistakable. During his father's final year, chemotherapy had produced a tremor that made every stroke uneven and slow. The deed signature was smooth, symmetrical, and confident, inconsistent with the physical limitations documented in medical files. The evidence pointed toward forgery rather than mistake. At the sheriff's office, the owner met with Deputy Lang, who explained that deed forgery typically requires prosecutorial initiation, and that, absent such direction, local law enforcement treats it as a civil property dispute. "You need a lawyer," was the deputy's practical advice. The owner retained attorney Margot Valand, known for real estate litigation. After a 30-minute review, she concluded that any competent court would void the instrument once challenged, but warned that discovery, depositions, and expert analysis could take 18 months and roughly $40,000. Instead, she proposed a lower cost, evidence-first strategy. Allow the opposing side to continue acting as though the forgery were valid while meticulously documenting every transaction, signature, and public filing. Each additional misstep would strengthen the case. Margot's document review also revealed a curious transaction. The HOA had paid the ranch's first quarter property taxes directly to the county, apparently to reinforce an image of ownership. She clarified that such payments confer no legal interest unless strict statutory procedures are followed over several years. Here, the act was meaningless legally but telling of intent. Days later, an eviction notice appeared on the ranch door citing the fraudulent deed as authority. It ordered the owner to vacate within 72 hours and included a handwritten note suggesting the HOA would purchase his equipment and livestock at fair market value. The owner did not respond. Instead, he photographed the document, logged the date, and filed it with counsel. The episode confirmed that the forgery was not an isolated filing error, but part of an organized attempt to dispossess him of the property. From this point, every step would be approached as evidence collection in an unfolding case of record manipulation and administrative exploitation. After the fraudulent quitclaim and eviction notice, the ranch owner shifted from reaction to strategy. The approach was systematic. Build a precise factual record, preserve every communication, and ensure every move complied strictly with law and code. Inside a cleared corner of the barn, he assembled a plywood wall into a working war room. On it, he pinned printed emails, copies of recorded deeds, permit applications, photos of survey stakes, and maps of the property boundaries. Each item was labeled by date, subject, and source. Red string connected names, events, and transactions, transforming scattered pieces of paperwork into a visible timeline. This physical charting of events became the central tool guiding all subsequent responses. The owner adopted a daily monitoring routine, checking county record portals at 7 o'clock each morning, while maintaining a contemporaneous logbook. Every new public filing or property change was documented with photographs and GPS coordinates. Stakes labeled SVWC appeared repeatedly along the fence line, matching the initials of Sienna Arquette's company. Each discovery was photographed, dated, and cataloged. Permit paperwork listing Sienna as applicant and referencing the ranch's legal description confirmed that the same parcel targeted by the fraudulent deed was now being represented as Lot 0B, Sage Valley Estates. The owner continued recording without confrontation, letting the documentary trail grow. To manage the complexity, he relied on a small circle of allies. Attorney Margot Valand coordinated all filings and correspondence with county offices, ensuring that each submission maintained formal tone and procedural accuracy. Cousin Tully, an investigator with a title insurance background, provided expertise in tracing document chains and identifying record irregularities. A new ally, Porter, a Sage Valley resident and retired accountant, offered to analyze the HOA's finances once suspicion arose about dues increases. And Rafe, a longtime welding colleague, would assist later in fabricating a symbolic yet fully lawful perimeter barrier, a structure that would become a permanent legal and visual statement. The fence was deliberate in concept and detail. Constructed of raw iron and powder-coated matte black, it extended approximately 1,200 linear feet along the shared boundary. Every component met code, posts sunk 4 feet deep, proper setbacks maintained, and full permits obtained in advance. Within the decorative design, however, the owner incorporated repeating metalwork displaying CRS 18-5-1002, Colorado's forgery statute. Every 50 feet, the numbers appeared as part of the ornamentation. When Delphine objected, claiming violation of community aesthetics, the owner cited the statute allowing agricultural fences up to 15 feet in height. His stood at 12. A county inspection by Officer Pacheco later verified compliance, even describing the work as excellent craftsmanship. Soon after, the ranch's water supply abruptly stopped. At the shared utility line that crossed the contested area, the owner found a new padlock and chain securing the main valve. Rather than cut it, he photographed the lock, recorded its serial number, and documented the coordinates, later hauling water manually for livestock to avoid any accusation of tampering. These visible, disciplined actions began shifting opinion within the HOA community. Several homeowners approached privately to admit they had been misled about earlier petitions, believing they were signing for maintenance improvements. Others expressed frustration that dues had increased 3 times under the explanation of legal costs. Questions spread through neighborhood forums. Where was the money going? And why was an outside property owner the focus of so much spending? By grounding every move in verified documentation and visible compliance, the ranch owner reframed the dispute from one of aesthetic defiance to one of procedural integrity. The fence, intended as protection, also became a physical ledger, each welded citation a reminder that the law itself was now part of the boundary. The groundwork had been laid for the financial and legal exposure that would soon follow. The shift from property dispute to financial inquiry began when residents, frustrated by rising dues and secrecy, demanded transparency. Porter, the retired accountant who had quietly aligned with the ranch owner, exercised his statutory right under Colorado HOA law to inspect the association's financial records. Initially, Delphine Arquette resisted, labeling the information confidential board materials. After Porter cited the state requirement for disclosure within 10 business days, the records were produced. What he found within the spreadsheets, invoices, and payment ledgers would reveal the true scale of misconduct. Over an 18-month period, $127,000 had been withdrawn from Sage Valley Estates Reserve Fund, with no corresponding service documentation. Among recurring payments were line items marked SVWC Consulting LLC, $4,500 monthly for 18 months, totaling $81,000. Cross-referencing public business filings showed SVWC was an entity formed by Sienna Arquette, Delphine's daughter, using a UPS mailbox in Denver as its address. No invoices described deliverables. Each entry simply read, Community Planning Services. Additional payments to Delphine herself appeared as administrative fees of $2,800 per month. The HOA's bylaws capped such compensation at $500, meaning she had been paying herself over 5 times the authorized amount for 3 years. Porter expanded his review beyond ledgers to property records and corporate filings. He discovered that the creation of SVWC predated social media promotion for Sage Valley Wellness Center, an enterprise advertising exclusive retreat memberships at $15,000 each. 30 had already been sold to Denver and Boulder clients, generating $450,000 in deposits. The business plan listed the future retreat's location as Lot 0B, Sage Valley Estates, a designation that, when matched to legal descriptions, corresponded exactly to Broken Antler Ranch. This linkage showed that funds sourced from HOA dues were being funneled into a private development on land that Delphine and her daughter did not own but had attempted to claim through the forged quitclaim. Deeded further corroboration came from banking records. A $340,000 construction loan to Sienna was approved by Vaughn, a local bank officer with a personal history with Delphine. The loan's collateral description included the phrase, "title transfer pending," referencing the same fraudulent deed. Timing reinforced intent. The approval date fell days after the deed had been recorded. Porter's compilation also unearthed a signed profit-sharing agreement, allocating 60% of future earnings from the wellness retreat to Sienna and 40% to Delphine. The agreement was dated 3 weeks before the ranch owner's father's death, showing that the plan to monetize the property pre-existed any legitimate title claim. Presented sequentially, these findings formed an unmistakable pattern. HOA dues from uninformed residents financed payments to shell companies controlled by the president and her daughter, while personal relationships within the bank and county planning office smoothed approvals and funding. The financial data converted community governance into a private enrichment scheme. Porter assembled his work into a 47-page report, complete with charts tracing each payment path, which later served as the central exhibit in both media coverage and official investigations. Events outside the spreadsheet soon mirrored what the numbers implied. The ranch owner's surveillance cameras captured nighttime footage of individuals herding his cattle into a trailer. One appeared to be Sienna. The livestock theft was reported to law enforcement, who opened a formal case. In parallel, Attorney Margot Valand filed the necessary probate challenge to contest the forged deed, while investigative reporter Kenna Briggs received a full evidence packet of documents, financial analyses, and photographs, with financial records now corroborating earlier property irregularities. The focus of the story shifted from neighborly conflict to a documented pattern of fraud, embezzlement, and abuse of authority operating under the banner of a homeowners association. As the financial evidence spread among residents, the case entered the public and governance arenas simultaneously. Investigative reporter Kenna Briggs reviewed the compiled documents, bank transfers, emails, and the forged deed, and confirmed their authenticity through county and state databases. Her preliminary article for the regional paper framed the matter not as a neighborhood dispute but as an emerging case of HOA misconduct documented through public records. Published online and in print, it drew immediate attention within Silver Pine Junction and surrounding towns, prompting both curiosity and unease among homeowners subject to similar associations. Within Sage Valley Estates, anger replaced confusion. At a community meeting organized in a local diner, Porter presented his charts showing missing funds, payments to SVWC Consulting LLC, and overcompensation to Delphine Arquette. Attendance exceeded expectations and the tone was factual rather than emotional. Residents asked how dues could increase repeatedly while reserves decreased. Porter explained statutory limits and the right of members to initiate a recall vote. Former City Councilwoman Iris Drummond, experienced in municipal procedure, outlined the Colorado HOA law provision, allowing 25% of members to petition for board removal. Within 3 days, canvassing began. 52 verified signatures, well beyond the 36 required, were collected, and a formal recall demand was filed with the county and delivered to Delphine by certified mail. The association president responded through escalation. An email blast to all members accused the ranch owner of being unstable, labeled the fence a safety hazard, and framed the recall as harassment orchestrated by outsiders. She offered Porter an envelope containing $15,000 in cash to withdraw the petition, an act he recorded in full. The recording captured her describing the payment as compensation for time, which later became potential bribery evidence. At the same time, she attempted to shape the media narrative by granting interviews to local outlets. Those efforts faltered when journalists independently verified discrepancies in the HOA's financial disclosures. Meanwhile, the pattern of selective enforcement continued. A county inspector named Howell issued new violation citations against the ranch for electrical and building code irregularities that had stood unchallenged for decades. Margot Valen's research linked Howell to Vaughn, the bank officer who approved Sienna's loan, identifying them as cousins, a conflict of interest that led to a formal ethics complaint. Each procedural pressure point created more documentation, strengthening the cumulative record of coordination. 2 additional discoveries deepened the legal exposure. First, Tully's review of the HOA's 2018 incorporation filings revealed a critical error in the legal description of Sage Valley Estates' boundaries. The mistake excluded 16 properties, including Delphine's own home, from the association's jurisdiction. This finding undermined her authority to collect dues or serve as president. Second, Rafe used a metal detector along the shared fence line and uncovered buried survey markers labeled SVWC, dated before the quitclaim deeds filing. Their existence proved that construction planning for the wellness center had begun prior to any legal transfer, reinforcing intent to commit fraud rather than a misunderstanding of ownership. These concurrent developments placed the HOA leadership under multifaceted scrutiny. Residents now questioned every expenditure. The media pursued open records requests. Regulatory complaints accumulated with county and state offices. What began as an isolated property boundary argument had evolved into a documented pattern of financial impropriety and governance failure. The conditions were now set for a decisive confrontation before public officials, where evidence would be presented not in rumor or online debate, but through formal testimony and verified records. The scheduled town council meeting promised to bring every thread, property, finance, and administration, into one unified, public forum. With the recall petition filed, financial misconduct exposed, and county records confirming multiple irregularities, the preparation for a formal public reckoning began. Attorney Margot Valen coordinated a synchronized series of filings designed to maximize accountability and ensure every relevant agency had jurisdictional awareness. 3 actions were submitted concurrently: an emergency motion in district court to void the fraudulent quitclaim deed, an ethics complaint against County Planner Brock Henley, and criminal referrals to the district attorney citing forgery, theft, and conspiracy. Margot described the approach as building a legal avalanche. If one filing slowed, others would continue the momentum. In parallel, she drafted a federal civil RICO complaint, naming Delphine Arquette, Sienna Arquette, Vaughn Gaskell, and Brock Henley as defendants, to be filed the moment the public presentation concluded or if interference arose beforehand. While the legal machinery advanced, fieldwork on the ground confirmed that the fraudulent scheme was moving forward despite exposure. During what the owner termed final reconnaissance, he and Tully surveyed the north pasture and found active excavation for foundations. Contractors on site referenced a wellness center project, producing permits that listed Vaughn's bank as lender. Photographs and serial numbers of all equipment were logged. Meanwhile, Porter continued monitoring the HOA's bank accounts as a dues-paying member. His oversight revealed a new $28,000 transfer from association reserves to an entity registered in Wyoming as a legal defense fund, Public records later showed the company's agent of record to be Sienna's former partner. The pattern suggested preemptive laundering to move remaining HOA funds beyond member reach. Kenna Briggs, the investigative reporter, coordinated with Margot to verify the new material. Her second article, titled Documents Reveal HOA Financial Irregularities Under Investigation, provided a factual update without revealing all evidence, preserving the impact for the upcoming town council session. Behind the scenes, she arranged for her publication's videographer to cover the meeting in full, recognizing the significance of what was likely to unfold. Then, in an unexpected turn, Brock Henley contacted Margot through an intermediary. Aware of mounting scrutiny, he sought limited immunity in exchange for cooperation. During a recorded meeting, he admitted accepting $12,000 and promises of partnership in the proposed retreat project in return for expediting permits. He delivered 90-plus pages of emails, text messages, and receipts showing Delphine and Sienna had pressured him to process applications despite his written warnings about unresolved title issues. Margot timed the submission of this evidence to the district court for 5:30 p.m. the day before the town council meeting, late enough to prevent the opposition from responding, but early enough for the clerk and local media to log the filings as public record for the public session. The owner secured a 15-minute speaking slot under the agenda's citizen comments portion. He requested a projector, screen, and sound system, explaining only that he would display property documents relevant to community governance. The presentation was structured as a 10-slide progression. First, authentic versus forged signatures. Second, the recorded deed. Third, the unverified notary stamp. Fourth, Porter's financial flow chart. Fifth, bank statements. Sixth, the email correspondence between Delphine and Brock. Seventh, construction photographs from the ranch. Eighth, Sienna's social media post geotagged on the property. Ninth, the bank loan documents. And 10th, a closing image of the ranch at sunset. Invitations were sent quietly to the sheriff's office, the state HOA regulatory division, and an FBI field agent connected through Deputy Lang. Each confirmed attendance. On the opposing side, Delphine prepared her own countermeasure. She announced a mandatory HOA meeting at the same time as the town council event, hoping to split attendance, and retained Denver attorney Reuter Voss at $650 per hour. According to the background, Voss privately advised settlement and restoration of the property, but Delphine refused. The lines were drawn. One evening, one chamber, one public stage where every document, transaction, and correspondence would be placed under direct scrutiny before the community and the law. The town council chamber was filled beyond capacity. Residents, officials, reporters, and investigators gathered as the ranch owner stepped to the podium. He opened his presentation with two signatures projected side by side. His father's authentic, tremor-shaken one, and the forged version from the quitclaim deed. The visual contrast drew immediate gasps. Subsequent slides displayed the deed's filing page listing HOA authorized agent, the UPS notary stamp with no verification record, and financial charts prepared by Porter. The data revealed $127,000 missing from HOA reserves,
$81,000 routed to Delphine's daughter's shell company,
and another $100,000 paid directly to Delphine, each figure tied to bank statements and recorded documents. Email excerpts appeared next, including one line that silenced the room. Once we establish access, the rest is easy. He'll sell or we'll foreclose. When planner Brock Henley rose from the audience, the atmosphere shifted completely. He confessed to falsifying permit approvals, accepting money, and promised shares in the wellness center, handing over a USB of corroborating evidence. The presentation continued with photos of excavation on the ranch, Sienna's social media post advertising Sage Valley Wellness Center, and loan papers listing the ranch as collateral without ownership. Law enforcement present in the chamber moved swiftly. The sheriff and FBI agent approached Delphine and Sienna, placing both under arrest for wire fraud, conspiracy, and racketeering. Reporters captured every moment. Margot's legal team simultaneously filed the prepared RICO lawsuit, time-stamped an hour earlier, ensuring civil proceedings followed the criminal action. By the meeting's end, the council unanimously voted to request a state investigation into Sage Valley Estates HOA. Attorney Voss withdrew from representation. Cameras recorded the crowd's reaction as realization spread. A neighborhood dispute had unveiled a coordinated fraud network. The owner's evidence binder, still open on the podium, marked the precise moment truth overtook deception. Within weeks of the town council meeting, the fraudulent deed was voided by court order, restoring Broken Antler Ranch to its rightful owner. Law enforcement and the FBI seized HOA and personal records from Delphine and Sienna Arquette, leading to formal indictments for wire fraud, racketeering, and conspiracy. Bank officer Vaughn Gaskell turned witness, and county planner Brock Henley accepted a plea deal with probation and a lifetime public service ban. The HOA underwent immediate restructuring. Porter was elected president, Iris vice president, and Cleo treasurer. Their reforms established dual signature requirements for all financial transactions, mandatory public reporting, and membership votes on any legal expense exceeding $5,000. Monthly dues were reduced from $340 to $185 after eliminating fabricated consulting fees, while an independent auditor began reviewing accounts annually. The HOA's first transparent budget earned widespread community approval. Civil restitution followed. The wellness retreat's $450,000 in pre-sold memberships was declared fraudulent, its assets liquidated, and Delphine's and Sienna's personal property seized to satisfy judgments. The owner's civil RICO suit settled for $188 million after attorney fees, from which he reinvested in the ranch, constructing a new barn, upgrading fencing, and preserving the law-etched barrier as both artwork and warning. He also established the EMTT Murdoch Legacy Fund with a $400,000 endowment to assist victims of HOA fraud and elder property theft. In its first year, 12 families received aid, setting a statewide precedent for grassroots legal advocacy. Sentencing completed the case. Delphine received 7 years in prison and $2.1 million restitution. Sienna 4 years and $890,000. Vaughn 2 years and $340,000. Sage Valley reformed into a transparent community, and the ranch stood restored. Its fence now an educational landmark symbolizing how documentation and persistence can reclaim both property and principle.